The trustee.
Sir, you need to stop. You're being in contempt of court. You need to stop, or I'll have the officer assist you in stopping. All right, Missy.
False imprisonment.
I want you to stop talking, or you can go upstairs to the county jail. Now, do you want to go to jail tonight? The second.
No, I also have a right to understand the nation's cause of this. I have a right to understand the nation's cause.
If you don't want to listen to me, you can go to jail.
I'm not being disruptive. I'm just trying to understand the nature and cause of the charge.
All right, officers, I'm gonna close.
What am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief.
Today we're looking at another unusual courtroom situation involving a man often described as a sovereign citizen. He appeared before the court facing charges related to speeding and not having valid insurance. Yet throughout the hearing, he seemed to treat the situation much more casually than most people would expect in a courtroom. Despite the possibility of serious consequences, including potential jail time, he continued arguing with the judge in a way that felt more like an informal debate than a legal proceeding. Instead of presenting a clear defense, he frequently spoke in law, confusing statements that made it difficult to follow his reasoning. Moments like this often leave viewers wondering whether the person truly believes the arguments they're making, or if they simply don't understand how the legal system works. It also raises questions about how effectively the judge managed the situation and whether the courtroom was handled professionally throughout the exchange. As the discussion unfolds, the unusual arguments and tense atmosphere make it clear that this hearing is going to be one worth watching. Let's take a closer look at what happens next.
In person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you can get right in front of that microphone, thank you.
Can you hear me?
I can. Sir, yes. You're charged in count 1 with speeding 82 miles per hour in a 65 mile per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. In count 2, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge. If, in fact, it had lapsed or something was happening so that you didn't have insurance on the vehicle at the time being January 4th, 2024, that is a B misdemeanor. The maximum penalties as far as jail time would be 6 months, although probation is usually granted. There is a mandatory minimum fine the court must impose of $300, but it could be as high as $1,000. You do have the right to hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if the county attorney approves you for diversion, you would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your record. If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. Your pleas, you have a choice of pleas. You can plead not guilty and we can set this for trial at a later date. You can plead guilty, admitting the charge, and we would proceed with sentencing. Or you could plead no contest, which is neither admitting nor denying the charges, but you'd still most likely be found guilty and we'd proceed to sentencing. If you want to look into diversion, we'll enter a not guilty plea to give you time to do that. You can always change your plea, but once you're convicted, pre-trial diversion is off the table. So
probably not eligible for diversion based on his driving record.
Oh, okay. Well, do you want to talk to an attorney then and discuss whether or not you have a defense? Or?
No, Your Honor, I would like to request a declaratory judgment due to there is no agreement for my performance under any agreement or commission of this court.
Well, I don't need an agreement from you, sir. So if I were...
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
I can already feel the tension.
As the hearing continues, the tension in the courtroom seems to grow, and you can almost sense the judge's patience being tested in real time. The man continues presenting long, complicated arguments about freedom and jurisdiction, apparently believing those points will somehow resolve the situation in his favor. However, cases involving driving without insurance or a valid license are usually fairly straightforward under the law, and arguments built on confusing or unsupported legal theories rarely change that reality. Situations like this often leave people wondering where these ideas come from, and how some individuals become convinced that such strategies will work in court. Many observers speculate that these beliefs spread through online forums, videos, or communities that promote alternative interpretations of the legal system. As the exchange continues, the tone in the courtroom begins to shift, and the discussion appears to grow more heated, suggesting that the confrontation may escalate further as the hearing goes on.
You can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if they're a not guilty plea for you and give you time.
I object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well, I object to you entering a plea on my behalf.
Your objection is noted, and if the time comes, you can appeal that to the Court of Appeals. Now, on the issue of attorney,
I would like to ask, who bring these charges against me? I should have the right to question.
All right, we're not going to have this debate right now. I've told you your charges. I've told you the state of Kansas has filed those through its attorney, Jill Gillette. Now,
well, I would like to call the state to the. I would like to call the state to the stand, Your Honor.
The I'm doing that.
State bringing charges against me. Who is it? How did I injure the state?
All right, this is your first appearance. I advise you of your rights. I advise you of your charges and possible.
Your Honor, I object to the proceeding, for I do not know the nature and cause of the proceeding.
I'm entering a not guilty plea, Missy. When is
I object to you entering I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
You're supposed to act as a trustee.
Sir, you need to stop. You're being in contempt of court. You need to stop, or I'll have the officer assist you in stopping. Missy? Well,
Your Honor, I would like to also bring to USC 12203.
Deputy Miles,
and also Article 3, the judge must operate in good faith and good behavior. So therefore, if you're making a threat towards me, then
Deputy, if he's going to keep being contentious, I'm going to have you take him into custody on contempt.
Then that would be illegal search and seizures, Your Honor.
Wouldn't you need to go back?
It will.
All right, Missy.
It's false imprisonment.
I want you to stop talking, or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
Your Honor, again.
Deputy Miles, could you come in and assist the defendant?
September 27th at 9 o'clock will be the court date.
September 27th, you said 9 o'clock?
Yes.
9 a.m. You must be back here, sir, in person at the courthouse, or you will be arrested for failure to come to court. Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
All right, so your first right is to have a hearing date, and that is September 27th, 9
As the hearing continues, it becomes clear that the man isn't picking up on the signals being given to him by the court. The judge maintains her composure while he continues to push the same arguments, even after the charges have already been explained more than once.
Can you hear me?
Moments like this can test the patience of any courtroom, yet the judge continues to handle the situation in a controlled and professional manner. At a T1 point, the man insists that he has the right to know the nature of the charges against him. In principle, that idea isn't incorrect. Being informed of the accusations is a basic part of due process under the Sixth Amendment. However, in this case, the judge had already explained the charges multiple times, and the issue seemed less about understanding the law and more about the defendant refusing to accept the explanation. Instead of moving forward with the hearing, he continues to repeat the same objections, acting as though the court is withholding information from him. Situations like this often shift from a legal discussion to a test of patience and persistence. The judge continues to clarify the process, while the defendant remains focused on repeating his arguments. As the exchange goes on, the real question becomes how long the judge will continue to tolerate the interruptions before taking stronger action to bring the hearing back under control.
I have a right to understand the nature of the cause.
If you don't want to listen to me, you can go to jail. Do you want to hire an attorney or apply for court appointed?
No, I do not. I don't need to hire an attorney, Your Honor.
You want to represent yourself?
I don't need to hire an attorney. I would like for you as the judge, Your Honor, to explain to me the nature and cause of the.
All right, I'm not going to appoint an attorney if you don't want me to. If you want, you said you don't want to hire an attorney. If you want to apply for court appointed, the officers have forms there that you can fill out.
I just want to understand the nature of cause.
If you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court September 27th at 9 a.m., you're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue. Does he have a bond? Looks like you do, because you failed to appear February 27th at your first appearance. So bench warrant was issued, bond was set at $1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000. Does that sound right? You put up $1,000 cash back in July 12th?
I'm still trying to understand the nature and cause of this allegation, Your Honor.
I will continue your bond unless you get yourself hauled into jail on contempt before you leave. I will continue your bond with the condition that you reappear here in person at September 27th at 9 a.m. So you've got your court date, you've got your bond, and we've talked about your lawyer. Now, you're wearing a U.S. Army uniform with the name Johnson on it. Are you in, or have you been in, the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. But I'm going to have those officers escort you to make sure you do so. So, Ms. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right. You can either walk out the front door with the officers, or you can walk upstairs.
As the hearing continues, it becomes clear that the man isn't picking up on the signals being given to him by the court. The judge maintains her
If you want to look
composure
into
while he
diversion,
continues to push the same arguments,
enter a not
even after the
guilty plea to
charges
give you
have
time to
already
do
been
that.
explained more than
You can always
once.
change your plea,
Moments
but
like this can
once you're
test the patience of any
convicted, pre-trial
courtroom,
diversion
yet
is
the
off
judge
the
continues to
table.
handle the situation in a
So-
controlled and
Probably
professional
not
manner that a
eligible
key
for
one
diversion
point.
based on his
The man
driving record.
insists that he has the
Oh,
right to know the
okay.
nature of the charges against
Well,
him.
do you want to
In
talk to an
principle,
attorney then?
that
and
idea isn't incorrect.
discuss
Being
whether or
informed
not
of
you
the
have a
accusations
defense?
is a basic part
No,
of
Your
due
Honor, I
process
would
under
like
the
to
Sixth
request a
Amendment.
declaratory
However,
judgment
in this case, the
due to
judge had
there is no
already explained the
agreement
charges multiple
for my
times,
performance
and the issue
under
seemed
any
less about
agreement or
understanding the
commission of
law
this
and
court.
more about the defendant refusing to
Well,
accept the
I
explanation.
don't need an
Instead of
agreement
moving
from
forward
you,
with the
sir.
hearing, he continues to
So
repeat the
if I
same
ever-
objections, acting as though the
Your Honor,
court
I
is withholding
simply
information
do
from
not
him.
understand the
Situations
nature
like
and
this
cause
often
of
shift from a
the
legal discussion
accusation
to a test
with
of
regard
patience and
to the
persistence.
jurisdiction
The
of the
judge
venue and
continues
nature
to
of this
clarify
action
the
until
process,
the
while the
prosecutor
defendant
properly
remains focused on
alleges
repeating
them
his
there.
arguments.
I
As the
cannot enter
exchange
a
goes
plea
on, the real
to the
question
charge
becomes
until
how
I
long
have
the
the
judge will
opportunity
continue to tolerate
to
the interruptions
raise
before
a
taking
meaningful
stronger
defense on
action
my
to bring the
behalf.
hearing
I
back
can
under
already
control.
feel the tension.
Either
Your
leave
Honor, I'm trying to
or
understand.
leave disruptively.
I'm not
That's
being
why an
disruptive. I'm
attorney
just
can
trying to
help.
understand the nature and cause of the
All right,
charges.
officers, I'm gonna close
What
it.
am I doing? I'm sitting here trying to understand the
If
charge.
if he gives any more grief,
All I'm asking is to understand the charges. This is
I've
for
told
the
you the
record. You said it's for the
charges.
record, so I'm trying to understand what am I
I
being
told you
charged?
the charges. Goodbye, sir.
I just want to understand the nature and cause of the charges, Your Honor. That's all I ask. It is your
I've
oath
gone
to
over
do
those
that.
with you. If you tell me what kind of questions you have, I'll be happy to answer them, but I've already told you.
Okay. Under what jurisdiction is these charges being brought to me under?
The state of Kansas has charged you with speeding 82 and a 65 and operating a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance and a bench warrant was issued and you were arrested and you made a bond of 1,000 cash or surety, posting a cash bond. Now you have to go to court and you have to answer those charges. You can
Your Honor, I
have
know.
a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
You're being charged under the jurisdiction of the state of Kansas under its criminal.
But according to the Constitution, there are only two
All right,
jurisdictions.
we'll have that on a later date. We'll be at recess, officers. Please escort him one way or the other, depending on his behavior.
But I'm still not understanding what you're charging me with.
Goodbye. We are adjourned.
But if she's the judge, I'm supposed to have clear and concise of what I'm being charged with.
The judge just said if you give us any problems with it.
I'm not giving y'all a problem. I'm trying to.
So you have put you in handcuffs and
Well, I'm waiting on the Your Honor to explain.
All right, Missy.
But that's it.
That's our last case on the docket, isn't it?
This is not good.
Yes.
All right. All right. Ms. Gillette, I'll see you at 3:30 docket.
Your Honor, can I please go home? Your Honor, can I please go home? I'll leave.
All right. Well,
Can I go home?
I left it up to them and I left it up to you and then they were to.
This courtroom moment turned out to be one of the strangest situations many viewers have seen. The man's behavior almost made it seem like he was pushing the situation toward jail time rather than trying to avoid it. Throughout the hearing, the judge carefully explained the charges and the court's jurisdiction in clear and simple terms, attempting to make sure he understood exactly what was happening. Despite those explanations, he continued repeating the same arguments and didn't appear willing to accept the information being given to him. The combination of confidence and refusal to acknowledge the court's explanations made the exchange feel both tense and unusual to watch. The situation also raises a broader discussion that often comes up in cases involving sovereign citizen style arguments. Courtrooms operate
You're
on strict
accused of
procedures,
operating your
and when
motor
someone
vehicle
repeatedly
without
challenges those
proof of
procedures with
insurance.
unsupported legal
Now, if
theories,
you had
it can take up
insurance but just
significant
couldn't
time
find
and
it,
attention from judges,
you can
clerks,
get the
and other
proof
court
to the county
staff.
attorney, and
While
she'll
the
probably
system is
dismiss
designed
that
to allow
charge.
everyone the
If, in
opportunity to
fact,
speak
it
and present their case,
had lapsed
prolonged
or something
arguments
was
over
happening so that
ideas
you
that have
didn't have
already been
insurance on
addressed can slow down
vehicle at the
proceedings for
time, the
other
time
cases
being
waiting to be
January
heard that in
4th,
the end. The
2024,
judge appeared to give the
that
man
is
several
a
opportunities
B
to cooperate
misdemeanor.
before finally taking a
The
firmer stance
maximum
to bring the
penalties
hearing
as
under
far as
control.
jail
Even
time
though
would
the
be
case
6
itself may
months,
not
although
have been
probation is
particularly
usually
complex,
granted.
the way it unfolded
There
made it
is a
memorable for many
mandatory
viewers.
minimum fine the
Moments
court
like
must
this often
impose
spark
of
strong opinions.
$300,
Some people
but it
see it
could
as a
be as high
frustrating
as
waste of court
$1,000.
resources, while others focus on how the judge
You
managed the
do have the
situation and
right
maintained
to hire
order in the
any
courtroom.
attorney of your
Either way,
choice.
it's a courtroom
If you
exchange
cannot
that leaves
afford
people
an
with plenty to
attorney,
discuss.